about that at length and won't go through it again unless the court has further questions.
There's
The
the
second
audio. There's
one
the audio.
is that the restraints at issue occur only in the aftermarket and not in the primary market. And that's satisfied here. We are
you. That is,
Dr.
did the lawyers define the market, or did you go to Dr. Evans and say, we have this issue, we'd like you to take a look at it, and did he come up with this economic argument himself?
Yes, Your Honor. We had a discussion with Dr. Evans about the issues in the case. We were speaking to him before the complaint was filed, and he has his independent views on the market at issue, which he's very careful, in fact, Your Honor, in his declaration to say that based on his analysis so far, he's reached a preliminary conclusion as to the definition of the market, and he is continuing to do work as the case proceeds and he gets more information.
The reason I asked was because his declaration raised the question. That is, his declaration indicated that the counsel asked him to address these issues as opposed to, well, you've answered the question, it's fine. The way he framed the analysis suggested to me that there was this potential that the lawyers had framed the market, not the expert.
And Dr. Evans' reputation would not permit him to just take a market that was thrust on him by counsel, and we wouldn't do that with him and ask him to put his name on the line if he didn't believe in the argument that he was developing and presenting to the court.
And does he have any reservations about the ability of either Professor Hitt or Professor Schmonzles? I don't know if I'm saying that right.
I believe it's Schmalensee, Your Honor.
Schmalensee. To opine on the topics in terms of their expertise?
Dr. Evans certainly has no reservations
They do disagree.
Sharing and taxes if not the alternatives impose some kind of competitive discipline in the market that's being proposed. And that's what the hypothetical monopolist test or the SNP test is intended to do. And Dr. Evans,
Let's go back to the aftermarket. You want to finish that up?
Sure, Your Honor. So I covered 1 and 2. The third factor in NewCal is whether or not the power that's at issue derives from express contractual agreements that were reached in the primary market. So here, there are no such contractual agreements in the primary market between the users of the iOS platform and Apple, that they will only download apps in certain ways. And Apple has not argued to the contrary in its papers about any contracts between users and Apple.
But there are contracts. There are contracts. There are licensing agreements between the plaintiffs and Apple.
That's correct, Your Honor. There are contracts between the developers and Apple, for sure. But the relevant question in assessing the third factor of NewCal is whether or not the users have signed onto a contract, or whether instead the power that Apple has over the users derives from their access to the consumers. The court in NewCal talked about special access to the consumers that derives from the relationship that, in that case, Icon had with the people who bought the copiers. Here, the information cost and switching costs and so forth that I will talk about in the fourth factor in a moment, those all derive from the relationship that Apple has with its users, and not from any particular contractual commitment on the part of the users to limit their access to apps on the platform. And so the fourth factor, as we've talked about a bit, and I can probably go through it more briefly, is in some sense the most important, and it is whether competition in the primary market for the smartphone software platform, whether competition in that primary market imposes competitive discipline in the aftermarket. So to put it in less antitrusty words and more English words, does competition to sell iPhones or iPads impose any discipline on Apple's conduct in the aftermarket? And this is the subject that Dr. Evans talks about at length, where he talks about the switching costs and the information costs that people face. And frankly, another very important factor is the relative costs associated with the two things. An iPhone is in the primary market.
Where does the
smartphone software platform
video game market come into play? You seem to ignore that entirely. And the Sherman Act is concerned about competition, right? It doesn't care about Epic Games specifically. It cares about competition, because through competition we get innovation. Consumers are certainly benefited from that. And if we look at the video game industry, of which your client is a part, the 30% of which you complain seems to be the industry rate, right? Steam charges 30%, Microsoft 30%, GOG 30%. If you go to console stores, PlayStation, Xbox, Nintendo, all charge 30%. Physical stores, GameStop, Amazon, Best Buy, Walmart, all charge 30%. Apple and Google charge 30%. Now, your client does it, okay, fine. But where competition, where that which you're complaining is seems to be what all the competitors are charging to be the industry rate, right?
So responses to
PlayStation,
both.
Xbox,
The first is you asked
all
about the
charge
video
30%.
game market,
Physical stores,
which I would submit is
GameStop,
not the
Amazon,
market that's
Best Buy,
at issue here. We
Walmart,
have a market for
all
apps
charge 30%.
broadly
Apple and Google
on
charge
the
30%.
iPhone.
Now,
With
your
respect to
client
the
does,
specific point
okay,
about the 30%,
but why do you say that? Where is
sure, I say that, Your Honor, because
and the reason in part I'm asking is because, at least from what I've read, 84% of all apps on the iPhone are free.
so
Your client complains
if I could try to
bitterly
tease out
about
two
the
issues that Your
30%
Honor raised in the question, and if you want me to
in
respond
his
to the
market,
other one, I'll
which
switch,
is
but I am trying to be
video
concise
game
to
apps.
both. The first is you asked
So
about
I looked at so it's not. So why? And you just want to gloss over. You don't want to address
want to
it.
make very
It's not.
clear, Your Honor,
So
is we
why? You
don't
just want
actually
to
challenge
gloss over.
specifically
You
the
don't want to
30%. The 30% is an outcome of the anti-competitive structure that we do challenge. We would like to be able to distribute directly on the iPhone ourselves without going through the App Store. We would like to be able to process payments ourselves on the iPhone without going through the App Store. We don't have a number that we are advancing that the court, for example, should conclude is the right number. I would agree with my friends that that is not really the role of an antitrust court to pick a price and set a number. The issue we're concerned about here is the structure in which there is no competition and 30% is selected entirely by Apple without any competitive constraint from other distribution.
Mr. Bornstein, you say that, but the evidence in that market doesn't support your blanket assertion. That's my point of referencing the rest of that, the rest of the players in that market, is that there doesn't seem to be evidence to support what you're saying.
Well, Your Honor, there are two things here. This is why I started earlier by referring to the proper market. The market that is at issue here, in our view, is not all of the different ways that somebody can reach a user to play a video game. That's not the right market. As Your Honor said at the beginning, the market definition is obviously an important part of the dispute here. And we're going to, I assume, continue talking about this through the rest of this litigation. But in order to assess what the right market is, the court needs to assess whether these alternatives impose a competitive constraint on what Apple can do in distributing apps. And I think it's clear that that those markets cannot. You can't, for example, play an Xbox when you are, on a bus. You can't.
No, but you can play a Switch, which you buy from Nintendo, right?
You can play a Switch, but there are, as Your Honor has seen in the papers, 63% of iOS users who play Fortnite play only on iOS. Most people don't have multiple devices to go out and buy a gaming console or a separate gaming PC, and certainly they don't multi-home in terms of using two different mobile devices, an Android device and an iPhone device. And what I think should weigh into Your Honor's consideration of this 30% and whether there is evidence that it is the product of an anti-competitive structure is the staggering opposition in the marketplace to this 30%. It's not just Epic who is complaining. It is the industry at large that is complaining about the 30% that Apple charges. And there is no doubt, I would say, that competition for the distribution of apps has been prevented completely on iOS. If it turns out, Your Honor, that after the opening up of the iPhone and the opportunity for people like Epic to do direct distribution, If it turns out at that point that Apple is providing a service that is worth 30% and people will pay it in order to get what Apple is providing, God bless them. That's fine. They are entitled to charge 30% if they can get it in a competitive market. Our concern is there is no competitive market right now, and there is no constraint on what they can charge.
All right, anything else on NewCal?
No, Your Honor. I'll just point out the other another important factor in whether there is a competitive constraint is just what Your Honor was talking about. Specifically, Google also charges 30%. In the primary market, there is a duopoly between Android and iOS, and there is no option for people who would like to go to a different place. So that, to my mind, is another reason why the primary market is not a source of competitive constraint for Apple's conduct in the aftermarket.
Mr. Doran, response.
Thank you, Your Honor. First of all, I guess I'll begin where the court did with Mr. Bornstein, which is the single market, single brand market. Your Honor, of course, correctly notes that this is something of a unicorn in antitrust law and a very specific thing. Judge Alsup in the SideStar litigation explained that it's counterintuitive that any product is so unique that it suffers no actual or potential competitors. This case does not fit the narrow exceptions created by Kodak and NewCal. There are two fundamental differences. In both of those cases, the plaintiffs were locked in to dealing only with Kodak and using Kodak parts exclusively and using Kodak repair personnel exclusively. And in NewCal, there was an extension of service contracts after there had been those plaintiffs had been locked in to dealing exclusively with NewCal. So first of all, to fit the Kodak or NewCal exceptions to the general rule that there's no such thing as a single brand market in the antitrust context, the developer here in this case must be locked in. But Your Honor obviously has the record well in hand and knows that there are many channels of distribution available to Epic to distribute Fortnite. And while Mr. Bornstein referenced a 63 million person figure, in that same paragraph 3 of Mr. Sweeney's declaration, he explains that only 10% of the average daily players of Fortnite are using iOS devices, meaning that 90% on any average day, 90% of the people who are playing Fortnite are using a device other than iOS. We also know, Your Honor, that Fortnite is based on, and Epic's business model is premised on, interchangeability of platforms. They urge people to use various platforms. And while Mr. Bornstein has asserted that not everyone has separate, or multiple devices, there's no evidence in the record on that. And instead, when we talk about those who have accessed Fortnite by one device, that does not tell us how many people are actually regular players on it. And there we see it as simply 10%. So first of all, Your Honor, there's substantial interchangeability. Epic uses that as one of its basic promotional properties that people can go on different devices and continue to